Arbitration Week 2023 with today's webinar on conducting arbitrations digitally, the Swedish way. In today's evolving legal landscape, embracing technology is crucial for a successful and sustainable process. In this webinar, we will delve into the Swedish approach to conducting arbitrations digitally, from case management insights from cases large and small. My name is Jake Lowther, Legal Counsel at the SEC Arbitration Institute, and I will be moderating today's distinguished panel. So joining us today, we have Erika, partner at Kilpatrick, Townsend and Stockton in Stockholm, who specializes in international and Swedish arbitration, both institutional as well as ad hoc arbitration and litigation. She regularly acts as counsel in commercial disputes, as well as sitting as arbitrator. Joining us online via link is Johan Sidklev, partner at Roschier and head of the firm's dispute resolution practice. He is specialized in commercial dispute resolution with extensive experience of international arbitration. He has acted as counsel in some of the world's largest arbitrations and has experience from arbitrators' appointments, including in investment arbitrations. We have Kristoffer, partner at Mannheimer Swartling and co-chair of the firm's dispute resolution practice group, and president also of the Swedish Arbitration Association. Kristoffer has experience from a wide range of areas and industry sectors and regularly sits as arbitrator in commercial disputes. And last but not least, we have Sandra Kaznova, partner at Hammarskiöld, who co-heads the firm's dispute resolution team. Sandra has broad experience of commercial disputes, including the sale and purchase of goods, post-M&A issues, shareholder disputes, employment and trade secrets as well. And Sandra is frequently appointed as arbitrator too. So, if I start with Johan joining us on the link, if you could please just provide us with a brief introduction to arbitration in Sweden.
Thank you, Jake, and hi to everyone joining online. Really good to have you there. Yes, that's quite a tall order to be covered in a couple of minutes, Jake, but let's try. Arbitration as a phenomenon in Sweden, that actually dates back to a time already before the Vikings. This was at a time when the wise men of the Swedish villages tried to resolve the village disputes by actually gathering at what this was then called the ting. But the procedure as we know it today really took form during the last century or so, and I'm noting that the SEC this year celebrates its 106th birthday. And of course, there are too many landmarks along that timeline to cover in a short introduction, but I cannot proceed without mentioning at least two or three. And the first one would be Judge Gunnar Lagergren. And he was very important for the development of arbitration in Sweden, but also internationally. Amongst his many achievements was that he was the first president of the U.S. Iran Claims Tribunal, and he has, of course, then chaired numerous tribunals in making many international landmark decisions. Another milestone to be mentioned, relevant for the development of international arbitration in Sweden, is, of course, the signing of the optional clause agreement in 1977. That was between the US and the then Soviet Union. This allowed US-Soviet commercial disputes to be resolved in Sweden with the assistance of the SEC. And soon thereafter, also China took the same action to transfer their international disputes to Sweden and the SEC. And the rest is history, as they say. So where are we today then? Well, in Sweden, we have our Arbitration Act. That was actually revised and updated quite lately, as soon as in 2019. We are, per definition, not a model law country, meaning that our Arbitration Act is not based on the model law as such, but it is very, very similar with only a few substantive differences. Sweden is also widely regarded, I would say, as one of the most arbitration-friendly jurisdictions in the world. Naturally, the SEC has contributed and continues to contribute to this picture. But in a more general sense, I would say Sweden has a pro-arbitration legislation in place, and a legislation that really upholds the principles of arbitration quite well. And the Arbitration Act that we have in place provides for a relatively comprehensive and clear legal framework, and it offers also parties flexibility in shaping their dispute resolution process. And the supportive stance towards arbitration, that extends also to our judiciary. Swedish courts are generally non-interventionists when it comes to arbitral awards, and they readily enforce and recognize both domestic, of course, awards, but also international awards in accordance with the New York Convention. And despite the relatively high number of challenge proceedings that we see in Swedish courts, fact remains that the Swedish legal system prioritizes finality and autonomy of arbitration. So moving then over to digitalization and closing in on today's topic, where are we in Sweden today and what has been the key drivers? I think that the swift introduction and general acceptance of digital arbitrations in Sweden presumably has been catalyzed by some of the fundaments of Swedish society, and I should just mention a few of them. I think first and foremost, Sweden's commitment to building and maintaining, but also upgrading its IT infrastructure has been instrumental in facilitating the adoption of digital technologies across various sectors, of course, including law. So we do have a strong IT infrastructure and connectivity. Second, I think Swedish society has embraced a digital-first mindset with a population that is rather tech-savvy and generally open, I would say, to new digital innovations. This also goes to Sweden's educational system that places a strong emphasis on digital literacy, something I think and hope that the future workforce will be well prepared to navigate the digital landscape. Third, the Swedish government has then, of course, rather actively supported a lot of digitalization efforts. Sweden is also known for its innovation-friendly environment. There has been a number of Swedish governmental funded research and development programs in this area. So that's a little bit of where we are today. And you know, of course, there are demands and challenges, but I'll stop there for now.
Thank you very much, Johan. I suppose just very quickly, picking up on that, would you say that this is more of a market-driven development, or is it the lawyers that are perhaps pushing for this digitalization?
I think, honestly, Jake, I think it's the market and the lawyers follow suit. But once the lawyers and the disputes community in general has gained an understanding of the advantages of the new technique, I think we have caught up with some of the developments, and today we also actually see great initiatives by lawyers driving the development forward, which includes such things as a greener arbitration community and other initiatives.
Thank you very much. I think perhaps if we go to you, Kristoffer, what are some of the tools and what are some of the Swedish innovations in the digital transition that you've seen?
Yeah, if I just start by taking one step back, looking at the 20 plus years that I've been doing arbitration, of course innovation has been something present all the way through that, although we haven't really realized it. But when I started with arbitration, everything was sent by fax. Email was never used to file submissions. I think most of the written submissions were prepared by dictaphone and hand notes and then handed to a secretary. So we can, of course, see digitalization in that entire process has happened in Sweden and everywhere in the world. But then when it comes to more procedural aspects of the arbitration as such, there is a great difference between arbitration and litigation in most jurisdictions, Sweden included, because even if the courts are also trying to develop and are very much using digital tools today, they have a much more rigid rule system. So every change need to be analyzed and sometimes go through a legislative proposal or a committee proposal and then be adopted by parliament sometimes, or at least by some adjustment of the procedures in the courts. Whereas arbitration is like one big innovation lab. There are so few rules, and within those rules that exist, we are free to do more or less what we want, as long as we comply with due process requirements. And that gives arbitration an evolutionary development. So it's much more quick to adopt and also quick to get rid of solutions that didn't work. And this has then fostered a tradition, a culture of innovation in arbitration, I think, internationally everywhere in the world, but very much so in Sweden. If looking at more concrete examples, the SEC was quite early in 2012 in adopting the Swedish arbitration portal, collecting all arbitration-related materials in one portal and having that generally accessible to anyone involved in arbitration. Today, it seems like a rather minor step, but 11 years ago, that was quite huge to have that available in that sense. Just to mention a few others, the SEC platform, which we can discuss further, I guess, came in 2019. So you can file all your submissions and have all the written phase of an arbitration conducted in a joint digital platform with the arbitrators and the counsel participating together, getting rid of basically all large physical filings. Also, sounds like a small step today, but the truth is no one was able to do that until SEC just launched it in 2019. Also giving that the ad hoc platform the year after when anyone was allowed to do that. So that's on the procedural side like that. And then also, which we can come back to perhaps, but how we actually conduct a case and present a case. When I started, you sat with binders at the hearing and you handed out physical documents, and that's it in technological advancement. Like the technology was that you had a photocopier. And today, all of that is basically virtual, or not virtual, but digital, and you have screens for anything. So is it an innovation in the sense that this is the new a new starship? No, but there are small things that just saturate everything we do. And looking today and 20 years ago, it's just a completely new thing. It's another thing. And now the development is even quicker, which we will come back to. And 2 years ahead, it will be even more changed.
Thank you. Yes, and I would like to underline for our listeners that the SEC does not want to receive any physical documents except for the final awards. Thank you. Just to underline how digital we are here. But Kristoffer, you mentioned the SEC platform. Erika, how have you found as an arbitrator, as a counsel, what is your experience of using the platform?
I'm tremendously happy that it exists because, as Kristoffer mentioned, you have everything in one place. When I log into the platform, I can see all the cases that I am involved in, both as counsel and as arbitrator, which is very convenient. I get notifications from the SEC platform regularly, which also is very helpful. But the most or the best thing with it is that you have everything in one place. You have all the submissions, all the exhibits of all the cases that you have, and you also have the contact details of the counsels involved in every arbitration and the tribunal, etc. So I find it very, very, very helpful. And you also do your communication as an arbitrator with the SSC on the platform. But I would also like to pick up on something that Johan mentioned about Sweden being a pro-arbitration society, and something that we as Swedish lawyer doesn't always understand is that our domestic companies also like to go to arbitration, and that is not the case all over the world. So I was a few months ago, I was talking to a girl in Austria where she said that she likes arbitration because then she gets to work internationally. But here we don't really have that situation because Swedish companies also like arbitration. So you get to do arbitration also when you do Swedish disputes. And something that you said, Kristoffer, about the collective intellect ever evolving. I think that is so true because every case you are involved in, you learn something new and you take that with you into the next case, meaning that the community as a whole gets better all the time. That's something that I really appreciate.
It's very interesting. It sounds a lot like the lawyers and the market generally are preferring arbitration, and perhaps its inherent flexibility, if you're doing it correctly, that might be one of its advantages, and therefore perhaps lends itself to this move towards a more digital
and I also think that on the question of who's the driver of change, is it like the users, the companies, or is it the lawyers? I think very often it's necessity that drives change. That you're confronted with a situation which you cannot really solve with traditional means, and you need to find a more efficient way of doing that. And that makes development perhaps sometimes quicker in the largest cases where you cannot really fit the file if you don't do that. But that's not entirely true, I think. I've seen a lot of development and innovation in the very small cases as well. Because in those cases, you also have a requirement of efficiency. And looking at, for example, the SEC rules on expedited arbitration, which as a starting point has as a rule that you should render the award within 3 months. And even though the case may be very small, that 3 months requirement necessitates that you find efficient solutions. And those solutions can have been invented in the very, very large cases, where you say, how can we do to compile this data? How can we do to organize the file in a way which makes this possible to adjudicate? How do we do in order to get a hearing even though people will not be able to travel in on that date? That kind of solutions are equally useful, and they also develop equally much, I think, in the small cases and the large. The only thing that needs to be there is this desire for efficiency. And if you have that, the innovations will take place.
Efficiency with, of course, due respect for due process.
Of course. I mean, that's a sine qua non. Yeah.
Sandra, what's your experience and what have you seen that perhaps hasn't always worked?
Well, if I can pick two favorites and then turn a bit to a double-edged sword. The first, maybe obvious favorite is the SEC platform. I think everyone agrees on that, and I would strongly recommend it also for ad hoc arbitration. It's fantastic. No emails getting lost with submissions or people talking about what was the last version of that Excel sheet, because it's always there. So that's fantastic. Then a personal favorite for me is video conferencing in terms of case management conferences. I think, and that builds on the flexibility of the arbitration proceedings, which is really one of the strengths, that whenever you have an issue in the arbitration, it is so quick as arbitrator to summon a brief video meeting to hear the counsel to discuss the topic, and then you can decide. You can avoid some of those lengthy emails and misunderstandings and actually solve things sometimes, not always, but sometimes quite speedily. So, and if you go back, like when I also started like 20 years ago, you had either you traveled to the case management conference and that a lot of time and effort and cost for maybe an hour of conferencing and planning, and then the issue popped up next week anyhow. Or you had those huge telephone conferences where you couldn't tell who said what. Was it Jake, John, or someone else? Now you can see everybody up front, very efficient manner. I think that's a great contribution, and probably driven by partly by Corona and COVID, maybe. So those are my two favorites. And then I was thinking a bit more about this digital solutions and presentations, and also what you said, Kristoffer, about now everything is on the screen. And I agree to that. And I think that in part is a very helpful development because you can present complex calculations or bring up evidence, whatever, making it really clear. But I think it's also important to be sometimes a bit critical and to think, why do I need this technique? Because it's actually about the message. So I had an experience on the kind of the opposite end of the scale, chairing an arbitration in another Nordic countries, where both counsel went there with the classical paper bundles and no screens. And I was like, okay, they're not using screens, but okay, please go ahead. And that was actually very well conducted, because then the counsel had put in more effort in their oral advocacy. So the risk you sometimes have with those fancy techniques is that sometimes people tend to spend little effort on their oral advocacy, relying on the technique. So that was why I would call it a bit of a double-edged sword.
Very interesting. So would you suggest then that there's some kind of best practice that you can?
Not in those terms. The only best practice I would really recommend is, as always, prepare and try and have a very reliable internet connection. That's the only point of big failure, when the connection doesn't work in digital. But that is not very often.
Yes.
I think on the issue of best practice, that it should be some kind of practice in each arbitration. So it doesn't need to be in best practice, but I think it's good to have an active tribunal that raises these issues and have the parties discuss, how do we want the presentation of evidence to be done? How do we want technology to be used? And so that you agree on ground rules. And to have some common understanding. That helps in my experience. For example, if you have a thing like a hybrid hearing, so where some are participating via video and some are not, or if you have a full digital hearing, it's good to agree on who should be visible on screen. Where should the camera point to? If you're in a room, should you have a camera that shows two of you, but the rest can be outside of the frame or not? Just so you have an agreement on these kind of things. So not best practice in the sense that you decide now what should work in all arbitrations, because then it goes against the nature of arbitration, I think. But an open discussion within each arbitration so that you have an alignment.
You mentioned an active tribunal. Would you say that this is something you might see more often in Sweden or abroad, or perhaps in other situations?
Well, it depends on. I mean, the classical. It's the stereotypical Swedish arbitrator is rather passive. It's a very strong reliance on the adversarial principle, and you should let counsel do their work. But I think in terms of issues of procedure and issues of presentation as well, the active arbitrator is typically not decided by the nationality of the arbitrator, but on the experience of the arbitrator. So if you have an arbitrator who herself has thought about how to use a camera, it will be easier for that person to raise that issue. But if you have an arbitrator that is just illiterate when it comes to those kind of things, you cannot expect to have an active one. And I guess that goes without saying, basically.
We had mention of the P word, the pandemic, I think, Sandra. Erika, have you noticed a change since we have gone back to normal, or has that really affected how you're both as counsel and as arbitrator, how you've seen arbitrations being conducted?
For me personally, no. I've had several hearings during the pandemic that was held in person, which was kind of unusual. So, no, not for me personally.
Perhaps that's the Swedish way,
Yes,
generally, when
probably.
it came to that management.
Yes, probably. But I think that this holding CMCs by Teams meeting, I mean, that is obviously here to stay. But I'm not sure that was an effect of the pandemic or would have happened anyway, just to save costs and be more efficient in arbitrations.
I've seen in several cases quite a development, I must say, in particular when it comes to hybrid hearing, so mixed hearings. So the full digital hearing, if you talk about the merits hearing, I don't think ever will be fully digital unless there is some kind of outer pressure for that, like a pandemic or a volcanic eruption on Iceland or something like that. But we like to meet. But the hybrid hearing, where you have some appearing in person or some not, I've seen used in several cases afterwards, and I think it's quite fascinating how that works. If you have a really, really good setup with cameras facing 4 directions, and this is for the larger cases, it's quite an expensive exercise, and then screens in front of everyone. I've had occasions where I've been sitting through those and had cross-examinations conducted, for example, and then afterwards, when I just think back on it, I cannot really make up my mind which I saw in real life and which were not, which were digital, because the experience is so close. So memory erases the differences, basically. So, and that I think we have now for the hybrid element. I think is very much here to stay.
Right, so it's a hybrid future in Sweden, at least, or present. I think there was some mention of the rules that need to the ground rules for a hearing, for example. In Sweden, would you say that there is a particular preferred source for such ground rules? Is it simply an ad hoc agreement each time between the council, or where might you typically source such rules, Sandra?
Start, of course, by asking the parties and the council for their views and see if it's possible to reach some kind of understanding, and otherwise the tribunal would have to go back and decide what meets the objects of the arbitration in terms of efficiency and due process and equality of arms.
So ideally, there's party agreement.
In my views, yes. The more the parties can agree on the process, obviously not on the outcome, because then they're not in arbitration, but the more the parties can own and sometimes be a little coached to own their own process, I think that's the way to go in arbitration, for me in personal. But I mean, of course, arbitral tribunal, if the council don't seem that experienced and the arbitral tribunal can see that this will probably not work out based on my experience, or I can see these potential issues, they should bring it up. But otherwise, yes.
And the earlier you raise it, the more likely it is that there will be agreement.
What stage? Oh, sorry, Johan, yes.
I think you just need from a protocol, a detailed protocol from the tribunal in order to make this work, as Kristoffer, I think, was alluded to as well, because you cannot really, this is an area where you should over-regulate, because otherwise people will start doing other things that you didn't think of as a tribunal when setting this up. So if the parties cannot agree, my recommendation would be for the tribunal to really step in and to issue a protocol and make sure that the parties follow that.
What are the particular items that parties can disagree on? Is it in a hybrid setting, or is it simply everything?
Parties can disagree on everything.
Yeah, I think there are so many things that the more you try to regulate, the more parties disagree on various things. They don't know if it's necessary and so on. And I could give you an example for which in my experience, this was the early part of the P word, the pandemic, where we had an arbitration which was fully digital. So everyone was from was on digital means. The tribunal was not together, so they were also separate. What I think there were like 10 different jurisdictions represented amongst counsel, parties, and arbitrators. 1 week hearing, and this was my first experience of engaging a third-party provider to fully run this virtual hearing. Now that is, I think, commonplace. We have big service providers that offer this, but this was new to me at the time. And of course, although this was a very much a relief for the law firms involved, not having to take responsibility for setting all the things up, and not, at least for the tribunal, not to have to take the responsibility of this. So that part, the hardware and the software, and that part was, that was a good relief for everyone involved. But here comes my point, and that was that it was suggested to use the external service provider's platform for uploading all material that was needed for the hearing. This, apart from becoming double work because we had already uploaded everything elsewhere, we were also provided with a online case manager from this service provider, who was then supposed to run the presentations, to share the exhibits and so on during the arbitration. And this was working so-so, because instead of asking your colleague to pull up exhibit X and paragraph Z, you ask this case manager from the third-party service provider to do so. And of course, it's a tall order for anyone to get acquainted with the documentation of any sizable arbitration, even being on the team or being on the tribunal. And here was a person coming into the hearing late and trying to navigate through all these documents. It worked, but it could have been a lot better, I can tell you that. And I'm not sure whether any other panelists have had more recent experience of such a case manager being online from a third-party service provider that has worked well. But this was not a good example in my experience.
Yes. Has anyone had experience working with a third-party provider?
Yeah, quite a lot, and I think it became better and better during the pandemic, and now I think I've had use of that kind of service providers in the hybrid kind of settings, which I referred to, and the one where I couldn't really recall whether I saw it in real life or not was made by a third-party service provider who basically produced the hearing, making sure that the cameras were operating in the right direction and so forth. So I think it works. But I also have experience from the early days when we started with these of situations where the parties should be sent out in their own separate breakout rooms to have their own discussions during the breaks, and there you could all of a sudden see someone from the wrong side in the breakout room, and that kind of things that just must not happen. But I guess that those are things that ought to happen in a situation like the pandemic, when everyone was just inventing new things as we went along, and then mistakes will happen. But now I think that we have managed to deal with that.
Would this be something that happens more on an international case or even on a domestic case, perhaps?
No, there's no difference in that, I think. And that's, I guess, one of the things with the hybrid hearings and digital hearings, that it erases that distinction.
So in a sense, the conduct is perhaps down to how the ground rules set between the council in consultation with the tribunal. Would that be an accurate summary?
Yeah, and the more persons you have involved who have an interest in develop these techniques to deal with technology, the better. And it's not like there's a huge advantage if those persons are on one side or only one in the tribunal, but you need to have some persons interested in it to help the others and to shape the procedure.
You mentioned experience as well. Someone perhaps who has done it before.
Helps, of course, yes.
Erika, you referred to some of the procedural tools that you've used and seen, the platform that you gave very good reviews of, and we're very happy to hear that you like the SEC platform. As counsel or as arbitrator, do you see any of those kinds of third-party providers or digital presentations of evidence that can but not always have an advantage, perhaps?
No, not really. No.
And is that possibly also the difference? Sometimes you mentioned a smaller case can at times not have much of a difference to a larger, but for reasons of efficiency or cost, etc. This might not necessarily be something.
I think there has been a discussion with technology about the quality of arms, and is this something that will benefit the stronger and be a disadvantage for the weaker? I think, based on my experience, that is not the case, because the tools we're using, it's different if we're using something really, really expensive. But basically, it's PowerPoint, it's Teams or Zoom, and quite simple camera solutions. I rather think that it levels the playing field, actually. And that's true also for the developments that we see now with AI and so forth, which we will come back to. I think that it will be so easily accessible for everyone that it will not mean that we will reach an area of equality of arms. That being said, there can be an equality of arms in the sense that some people are just not adapting to technology. But that's a comparison I've done before in this context. That was exactly what happened when John F. Kennedy ran against Richard Nixon. And it was the first televised debate in the U.S. election, and it was very clear, according to history, that Nixon was not comfortable in debating in front of cameras, and Kennedy embraced it, and because of that he gained an advantage. That can happen now too, of course. That whoever is more enthusiastic about embracing a new medium or a new technology will be better to use that one. But it has nothing to do with resources, or very little to do with resources and economic ability.
Yes, I understand that JFK was more... Oh, sorry, Johan, yes. You go.
To that, I mean, you sometimes hear arguments about the digital divide and so on, that depending on, more developing countries not having the same possibility, etc. I think for all intents and purposes in the sphere where we are operating, I don't think that is much of a problem, really. I think we have other problems, and that was already mentioned, technical proficiency amongst the ones participating, and then connectivity issues. I mean, it's as easy, but as also turns out to be very difficult sometimes to make sure you have a backup connection, to make sure you make test runs, etc. But it's always something. There's always something glitching or connectivity failing. So I think those are the more irrelevant issues. And then, of course, in the bigger sphere, there might be a digital divide, but not maybe primarily in international arbitration, because the ones using international arbitration have at least access to the necessary tools to run a show like this, for them, in my experience at least.
Johan, would you normally see some of these, how to deal with a dropped connection, for example, in the parties protocol then?
Yes. So in such a protocol, there should be making sure that there is a backup Wi-Fi, for instance. If you have cable connectivity, you should make sure that there is a good connection to switch to Wi-Fi solution, either through the telecoms net or something else, so that you can easily go to that backup solution.
I was also just going to say I understood that JFK had a very good makeup artist for that televised debate, and Nixon had not had the same advice, and so no, I won't go into cosmetics, but
it's always about the details.
Well, right, it's always about the details. But we have had a question from the audience, and that is whether we have on the panel any good or bad experiences of conducting arbitrations digitally. And we've heard a bit about with the binders, Sandra. Does that mean you have an experience of the other side of a purely digital arbitration?
When we mean a purely digital arbitration, I guess we mean a digital main hearing on the merits. Yes, that was quite common in my experience, in particular under the pandemic. I participated mainly as arbitrator, I think, in a few of those. That worked out very well. But then there were somewhat limited arbitrations. If you ask me now, I would consider that, or with the parties, on a very case-by-case basis, with a starting point that a in-person hearing, I think, or a hybrid hearing is the starting point and the best, because it's typically better to meet, it's more enjoyable, and between the arbitrators, it's easier to take time and communicate, I think, more smoothly. But on the other hand, if you have limited case value, not that much case material, perhaps involving people in various locations, very spread out, it might be cost efficient and better to do the whole thing digitally. But now I would say I would prefer, as a starting point, I would prefer to have an in-person hearing.
Erika, would you?
Yeah, I would like to pick up on the digitalization. I mean, obviously we have come very far from faxing in submissions, and although I didn't start with faxing in submissions, I did went through the whole hassle of filing them via email and just waiting for the non-delivery emails that you got, and then you had to divide the exhibits into further emails, etc. But there's one thought in line with that I would like to discuss with you, and that is, the question is it too easy to file large volumes of documents? Does that mean that we somehow lose the thought process that should go into the case analysis and us sorting out what is relevant for a case rather than just submitting everything? For example, when you are an arbitrator and parties submit exhibits which are hundreds of pages long with invoices, for example, where are you as an arbitrator supposed to look in that whole file of several hundred pages of invoices? I mean, how do you deal with that? And is this really a good thing, or should we make further efforts to really think about the case and analyze it more properly than just submitting things?
My thoughts on that, a few?
Sure.
Yeah, because I think that this is a real challenge, and it goes to due process, actually. If the arbitrator is not able to understand the evidence, then the opposing counsel will not be able to understand it either, and how should you respond to that, and so forth. I think there are very good examples in procedural orders on how you should present evidence, and clear indications that evidence not presented like that will be disregarded. Problem arises if it's not, basically. But generally, I think we've had this development thanks to technology, where access to information has been so much easier, and that has made the case files grow. For example, just a simple thing as earlier, maybe the focus was on 4 letters. Now it's on 2,000 emails.
Exactly that.
And you can submit all of them. So technology has helped us to access that information. I think now in the next step we will start. We must use technology to limit that information. But I think it will help in that too. So there are 2 sides to it. One is counsel being responsible for presenting a good case and an understandable case, but the other side being that technology has led us here, and now I hope that we will use technology to reverse parts of it.
I would add potentially filing huge number of documents and exhibits, if that is kind of fueled by the easiness of doing that digitally, comes also potentially the problem of authentication of those documents. Do we get into disputes what is authentic and not, and so on and so forth, when you just file a lot of exhibits? And while I'm speaking, and on the question that you posed from the audience, Jake, on what works and what not, I know Kristoffer takes a very good view on doing the cross-examination and so on digitally, where I am potentially of the other opinion, that I still think that the face-to-face cross-examination way outweighs the benefits of that, outweighs the easiness of digital solution, especially if you have a really sensitive cross-examination where you want to have the ability to monitor both the witness and the tribunal. And I know Kristoffer will say, in my experience, I have screens for everyone and so on. It's a perfect producer of this hearing, but still I find that not good enough, really. When it's a normal witness, it's all about the facts. But if you do have a really sensitive cross-examination, I would really prefer to do it live over being virtual.
As counsel, that you think that you will make a more effective cross-examination then? If you do it live, and that's because I have, as you already know, I have experience of where you have a very focused cross-examination. So you have a witness that you know is in his or her own room with a pointed camera, and it can become very tense, actually, and I think it works. But then the other side of that is that what some people point to is that, no, I don't like witness examination to be digital because from the arbitrator perspective, I like to be able to assess the credibility of the evidence. And that is easy to say, but I think science goes against it, that there is even psychological science saying that it's even better not to see the witness at all if you are to assess the truthfulness of their testimony, because there are so many distractors if you see the witness, and you will judge the credibility of the witness based on the watch, the tie, the hair. So some things we want to have as we used to have it because we are used to have it like that, without there being any real scientific reasons that goes to the core of it, that goes to due process, I think.
I just want to jump back quickly because I thought it was a very interesting statement on the perhaps excessive amount of documents in some arbitrations and whether the digitalization has also been a cause of this, or a correlation at least. And I was wondering if this is a more across the board, more Swedish, and I was wondering if tools such as the statement of evidence that is more common in a Swedish arbitration might help to perhaps force people to cut down the amount of documents that they would use, at least in the Swedish context.
I think this is a general problem and not something that is typically international or domestic. And I think that the domestic arbitrations or the Swedish connected arbitrations have evolved into not having a statement of evidence. So rather adopting the international way of doing things. But yes, I think that could be a helpful tool to bring back the thought process of the lawyers.
Does anyone want to clarify for our international audience what we mean by statement of evidence? Sandra, perhaps?
Well, in terms of the written evidence under Swedish law, you would state not only the documents you rely on as written evidence, but also what they are sought to prove. And maybe many practitioners perceive that as unnecessary. It's still quite kept at court, but not so much in arbitration anymore. And I share that view in general. But I would also add to the point, if there is an arbitration where counsel are submitting loads of documents and the arbitrators don't understand the relevance, then the counsel are not doing a good job, in my views. You're supposed to clarify. You have to have a thought on why you submit these evidence or groups of evidence, categories of evidence. And maybe the tribunal should ask if they are just drowning in massive loads of information. Why is this relevant? Could the party please specify?
Yeah, I totally agree with you, Sandra. I'm a firm believer of that the council's work is to make life easier for the arbitrators. But still, this happens.
Or at least present their cases. There is some work associated with being an arbitrator, but they're representing the parties and the parties' interest. You should really clarify. But of course, it's a natural consequences of before we had those access to all emails and all databases and all, you had to ask people to hand over the 2 or 3 important emails they had written. And now you can search enormous amounts of databases and produce much more information, but still.
I think importantly, even if you think it's counsel's work, yes, it is, but it's also for the arbitrators to give directions, I think. If things go out of hand, a good tribunal steps in and takes care of that and direct how it should be done. So that's, again, the need when it comes to these things for an active tribunal in the sense that they're not afraid of raising issues and discuss them. And I think if you do that, typically there will be some kind of agreement or common ground on how you should do it.
Does that get easier for the arbitrator depending on the rules that are applicable? For example, SEC rules have very strict deadlines and also obligations that the case should be managed, conducted efficiently, expeditiously.
Can be, absolutely. I mean, if you have that kind of things to point to, you can always have that as a benchmark against which you must measure how efficient should we be. Because in the general rule on the model law and typical arbitration acts is just that the arbitration should be conducted efficiently. But if you have firm deadlines, of course, you have much more power behind your words if you try to enforce that obligation.
But in my experience, it's very difficult to dismiss evidence that is submitted. Very, very difficult.
Well, I'm conscious of time. And
have it dismissed is difficult. To dismiss is not.
But I thought one of the things that I know we'd also like to just briefly touch on is perhaps where are we going now? We've had the context in terms of Sweden as a generally pro-arbitration jurisdiction with a market that has a high expectation perhaps of efficient digital solutions that do not compromise on due process. So perhaps, yes, if Kristoffer, perhaps you'd like to start where you see we are going in Sweden in terms of how we conduct hearings.
Looking into the future.
Yes.
And I mean, I do this from Sweden. I'm Swedish, so therefore it's about Sweden. But I think this all holds true for everywhere. When I was talking at the beginning of this hour about what has happened in the 20 years that I've been doing arbitration, I think that the combined development that I've seen in 20 years will be smaller than the combined development that I will see in the next 2 years. Now change will happen at the pace that we haven't seen before when it comes to digitalization. And I'm talking obviously about artificial intelligence that will affect everything that we do, in my opinion. I don't think that if looking at a typical case from the perspective of counsel, when we get the first call, when we get the first information, how we analyze that and we put together first a memo, then perhaps a strategy memo, a case theory. We produce a first draft, a draft of a statement of claim or a request for arbitration. We initiate that all the way up to the hearing and then the award. All those steps will be the same, I think, in the near future. And when I talk about the near future, I talk about the next 1 or 2 years. But none of the steps in that entire procedure, I think, will be done without the involvement of AI in one way or another. And this is a change that I think in some of the cases I'm working on will happen before Christmas. Some of them will maybe not be fully digitalized in the way that I foresee that they will soon be until sometime during next year. But I think it's now it happens extremely quickly on the backdrop of ChatGPT-4 basically, but with lots of applications that can be produced by anyone basically with the help of ChatGPT very, very quickly. So I think that all we can say for now is that everything we do will be assisted in some way or another by AI. That I can say for sure now, basically, that will happen within the next year. What that will lead to in the next step, I think, is not possible for us really even to conceive of or imagine, because the development will be so quick. What will not change, hopefully, is the judicial decision making as such. It's on the EU's radar now, and they are proposing regulation around AI and the use of AI, and have a red list for which AI should not be used at all in the interest of society, basically. And on that red list, they have judicial decision making as a proposed absolute prohibition where you cannot use AI. So that means, for example, that it if that relates applies also to arbitration, which I think it will, that an arbitral award produced by AI or the decision rendered by AI will not be valid and legal. But that does not say, I think, that the arbitrators will not use AI in many ways, both to structure information, analyze information, and perhaps even to give them first drafts. So I think even that sector will probably be affected by AI, but I hope to a lesser extent. So as counsel, even if you're using AI, you will do that to aid you convincing a human.
Just quickly, would that EU proposal also apply even when the parties themselves have agreed that it will be an AI decision that an arbitrator renders?
That I think is an interesting arbitration law question. So if the parties themselves have agreed now, for example, to have an arbitration where you roll a dice and that decides the outcome, is that a valid agreement? And there's debate about that, I think, in various jurisdictions, and probably some kind of thinking needs to go into a judicial decision. So it may be that kind of agreement is not valid, but it will always be valid on a contractual basis, I think. So if you agree that as a matter of contract, this should be solved in the way that that the AI decides, then that ought to be valid as a matter of contract, I think. But if it's valid as a matter of a judicial decision, I hope not.
Well, I'm conscious of time, but Erika, just quickly, do you agree with Kristoffer's vision for the future, or are you a little skeptical still?
Yes. Although I'm the youngest here, I'm a little bit more skeptic than Kristoffer. I would not go as far as the Swedish guy who said that internet was just a fad, because I don't think that AI will be a fad. But I'm currently more of a skeptic. But I'm very curious, so we'll see where this goes.
Just to clarify, I'm not enthusiastic. I'm just seeing that this is happening. And if I had a choice, I would have preferred it to be like last year. But this is where we're going.
Right. Well,
I could comment.
Yes.
I think it's very difficult to speculate, of course, as to the timing of the development of these things. We know for sure that it's very quick and it's happening as we speak. At the same time, we've heard before that this will innovations that will revolutionize our work, and it turned out not to be as dramatic as many of the predictions that were then around. But let's see. I'm sure that it will affect the way we work, but also a bit of a thing that triggers my mind would be, to get really good assistance in the courtroom, in the arbitration hearing room, with your difficult cross-examination question, someone making up the questions as we go along, just punch in the answers and get the new question quickly. That would be wonderful, wouldn't it?
That I think you can do now, actually.
Yes.
So, ending there on a note of optimism, thank you so much, Johan, Sandra, Kristoffer, Erika. Thank you so much for joining us, everyone in the audience. We hope to see you again during the week at the SEC Arbitration Week 2023. And of course, please do follow us on social media. And we look forward to seeing further developments now in conducting arbitrations digitally the Swedish way. Thank you very much.